This matter was coming up for plea today. The state, from the onset, made an application to have this matter withdrawn under Section 87A of the CPC. Counsels for the accused, led by Mr. Orengo and Mr. Kanyama, questioned what informed that decision. It was submitted on behalf of the accused that whereas the state can make an application to withdraw the matter, they must provide reasons. It was also submitted that the accused have a right to be presented before court as soon as possible and within the timelines provided under the Constitution. The counsel also brought this to the attention of this court about other suspects currently not before this court. And there is one said to be within the court precincts, that is at the car park. And there is another one who is still in police custody. This court was urged that while making a determination on the issues raised with this matter, should also affect the rest who are not before court. Mr. Kanyama also rooted for withdrawal of the charges under Section 202 of the Criminal Procedure Code, and that the accused person should be acquitted. There was also submission that in the course of arrest, the suspect was subjected to degrading and inhuman treatment contrary to the dictates of the Constitution. In rejoinder, Ms. Kariuki for State submitted that the DPP have powers to review a matter at any stage. I have considered submissions made by the state as well as by the counsels representing the accused persons. It is a fact that the state have powers to make an application before this court to have a case withdrawn at any stage before final determination. That decision, however, to withdraw must be considered by this court and either allowed or disallowed. The law requires that the prosecution must give reasons for withdrawing, for making such withdrawal. The suspects in this case are yet to take plea. The court have not had the benefit of evaluating the evidence. It has been indicated that the decision to withdraw was on the basis of a review. In principle, the defense have no issues with withdrawal. And Mr. Kanyama urged this court to make an application to withdraw this matter under Section 202 of the CPC. Looking at this section, it only applies where a matter was scheduled for hearing. The complainant who had notice to appear and testify failed to do so. On application, the state can then make an application to dismiss the charge and withdraw under Section 202. It is not applicable in this scenario. The state has given reason why they are making this application for review. It's on the grounds of, for withdrawal, it's on the ground of review. I will therefore allow the application to have this matter withdrawn under Section 87A of the CPC. Some other issues also, but just as a reminder, and going by the dictates of the Constitution, the state, that is the prosecution, before arresting and prosecuting an accused person, must also ensure that they have evidence in their possession which can sustain their cases in court. There is another application which affects other suspects who are not before court today. And if there is a suspect who is within the court presence, then the charge sheet should be processed in the normal manner, and the process should be hastened. For the other suspect who is allegedly in custody, that case is not before this court now, and the court cannot issue directive in vacuum. The party affected have liberty to move court appropriately by filing any necessary application, which will be considered, and the court will give the appropriate directions. Lastly, The rest of the issues has to do with evidence, and there was the issue of Companies Act, and even at one point there was the issue of patron. The court is not seized of such facts at this stage and cannot make any conclusive finding. Those are the directions of this case.